Chris, perhaps you could just quickly provide students with a brief summary of kind of your academic and vocational journey to date.
Sure. And good evening. Thanks very much for having me. And good evening, everybody watching. It's good to see so much interest in the law, in criminal law, and I hope in a few cases in practice at the criminal bar, where I've been for the last 26, almost 27 years. So my journey, how did I sort of end up here? I went to state schools. I went to comprehensive school in Milton Keynes, of all places, in the 1980s. It was not the golden era of state education, certainly not comprehensive education at that time. Far too long ago for any of you to remember, but it was Thatcher's Britain, right in the middle of probably one of the worst periods of state education in terms of investment, in terms of support from government that we've ever had, or certainly since the Second World War. So I didn't really latch on to education very much. I spent a lot of my kind of secondary education not going to school, bunking off, absent for days, weeks, or even months at a time sometimes. Although there was educational benefit in some of the things I got up to, which I won't describe for your audience. But you know, I learned stuff that maybe wasn't in books and wasn't in the library during that journey. At the age of 16, I left school and decided to make my fortune by selling donuts and cans of Coke on the beaches of the south of France, having hitchhiked there, age 16, with a friend of mine. It may not surprise you that that was not the most lucrative employment or self-employment anyone ever undertook. And within a few weeks, I'd run out of money and stock, having eaten or drunk most of it. So I then headed back to England to find that my parents had moved from Milton Keynes up to Merseyside, almost 200 miles away. They had bought a small semi-detached house up there, but it had one small back bedroom left, which they allowed me to have on the condition that I either got a job or went to college. In one of those sort of quirks of fate, which I suspect is the main quirk of fate that leads me to be speaking to you this evening, this college that was right near their house, as it happened, was one of the best state sixth form colleges in the country at the time, with some of the best A-level grades of any state sixth form college in the country. And miraculously, despite my extremely poor exam results from school, they let me in. And I did A-levels there, and for the first time in my life, actually had teachers who were interested in the students and the pupils. Unlike my secondary school, where the most interest for most of the teachers was how early they could go home and how soon it was till the next fag break. But sixth form college was a different animal. My form tutor was a Cambridge PhD in English and a fascinating and inspirational teacher. My politics teacher was an absolutely fascinating, inspirational teacher. And indeed, all of my teachers across my A-levels, I did English, French and politics, as well as general studies, were brilliant educators and brilliant teachers and powerful and passionate, in their interactions with everyone in the college. So I did really well at A-levels and had the choice of pretty much going anywhere, and chose to go to Manchester University, in part because of the nightlife at the time and to this day being one of the best in the country. But also because it had a fantastic faculty of law, and still does, and some of the great law teachers and professors of our times were at Manchester, and I think one or two of my lecturers are still there actually, but they may be getting on a bit, I don't know. But anyway, did a law degree at Manchester. I then went on to do the bar, what was then the bar course, the bar professional training course, I think it was called at the time, and did really well at that. And really enjoyed the course. It was a fascinating course. I think I was the first year of the vocational course. Up until that point, it had been a highly academic bar exam, which, as it was previously called. And I was very fortunate that I came out with no contacts, as you may have gathered from my background. My parents had very ordinary jobs. My dad was in the building trade, and my mum was a care assistant, and actually worked in John Lewis in the department store before that when I was growing up. So had no contacts, no lawyers in my family, nobody I knew who I don't think anybody I knew had even been to university. Certainly nobody in my family had before me. And so, but by a process of sort of miraculous connection, I managed to get pupillage, and it was a different world back then. In that pupillages were not part of an organised system. Each chambers had its own kind of process, and there were no kind of fixed rules as to how pupillage was organised. But I managed to get pupillage in a very small criminal defence set in Manchester. Only had about 11 or 12 tenants. And I started my sort of career in Manchester doing criminal cases, and you know, I was doing burglaries one day, I'll be doing a drug trafficking case, or you know, magistrate's trial for assault the next day. Even to the point, in 1 month in my early career, I did 20 trials in 1 month from start to finish. Now, how do you do that? The answer is you go to the magistrate's court every day, and you get a new file, and it's a trial. And as it happened, the odds of this happening are virtually zero, but 20 trials stood up in a month and went from beginning to middle to end, one a day, every day for a month. And that was the kind of level of advocacy experience that I was exposed to as a young criminal barrister. Case after case after case. Sometimes I'd be in the Crown Court with up to a dozen briefs in a day. So that could be a sentence hearing, a committal for sentence, a plea in one court. Then I'd be dragged off to another court. There might be more briefs arriving at lunchtime because, you know, cases needed covering or they've been missed. And so it was an incredibly kind of intensive experience of being exposed to junior practice at the criminal bar. In those days, and still to this day, although I think the volume of work is slightly lower for very junior practitioners than it was when I started, for a number of reasons. But then I spent the next, you know, as I said at the beginning, I've been in practice for over 26 years now, and I spent the first 10 years or so building a really heavy Crown Court practice. The next 10 years consolidating that practice, becoming a leading junior, in big drugs conspiracy cases, fraud cases, armed robbery conspiracies, you know, meaty kind of serious criminal and organised crime cases, which were my specialism as a sort of senior junior. And then I took silk after 19 years, just coming up to 20 years in practice. 8 years ago now, I've been in silk 8 years, which makes me feel really old, even more so perhaps than the 26 years at the bar. But I took silk in 2013. Round about now, this time of year, late February, early March. And since taking silk, my practice has kind of developed in a lot of different ways. I do a much more eclectic mix of cases now. I still do some organised and serious crime work. I do a lot of work in sort of high profile cases for well-known people, high net worth people, individuals, corporations, and sort of corporate advisory work, whole like eclectic mix of stuff. And then in the last couple of years, my career's taken, you know, something of a parallel term, because I still practice every day, and I'm still involved actively in casework. But as you can see from behind me, and also, you know, some of you may know already, I have a book out which came out last summer called Justice on Trial, which is a kind of deconstruction of everything that's wrong with our justice system, and a kind of bold kind of reform agenda, saying why we should legalize drugs, why we should basically stop using prisons in the way that we do. And in fact, I argue we should largely close them down, why we should stop criminalizing children at all, and why no child should ever be placed into the criminal justice system. So all of this is born of my kind of many years of experience. I also mentor people across different age ranges and different stages of their career. And I'm involved, as I was explaining to the team here before we came on the session, I do interviewing for scholarships for Gray's Inn, and I spent most of last week interviewing. I did 60 interviews for scholarships in the last week, in fact in 3 days of last week. And so I get to see a lot of the young people coming who want to join the profession. I have a real passion around social mobility in particular, but also diversity at the bar and in the legal profession. So, you know, kind of, I hope that's a nutshell for you. I mean, it's probably taken longer than most nutshells do, but that's kind of who I am and where I came from. And does that help, Tom? Is that what you wanted to hear to start off with?
Yeah, that's great. Thank you for the context, Chris.
Thank you so much, Chris, for kind of shedding light onto your journey. I think it's been really useful for us students as well, and how you've mentioned you had a very non-traditional background to the bar. Could you please elaborate? You've mentioned that you joined a criminal defense set. So what made you choose defense over prosecution? If you could slightly elaborate on that, please.
Yeah, it's a very good question. So I suppose backtracking a little, why did I choose to become a criminal barrister at all? And the answer is because I went to court. I went to watch cases in the Crown Court as a sixth form student in between my first and second year of A-levels, and sat in the public gallery, as it happens at Liverpool Crown Court, and watched just the most incredibly fascinating cases of murder, drug trafficking, and I was just carried away and utterly absorbed by the process, by the drama of it all, by the the sheer human interest and the sort of psychological features that go along with a criminal trial, particularly a serious criminal trial, and so that's what got me. I mean, I absolutely became completely addicted to the idea of being a criminal barrister from watching that, and that persists to this day. So that experience of 30 odd years ago has carried through my whole career, and I'm still just as passionate, just as excited about criminal justice and criminal trials as I was when I saw my very first trials then. But as to your question between criminal and defence work, I just feel like my personality, maybe it's to do with my background, maybe it's just to do with my character, but I feel like I am much more comfortable challenging the authorities and challenging the status quo than representing the establishment and the status quo. But I didn't ever make a positive decision, actually, to become a defence barrister. It's just that my pupillage was with a defence set, which pretty much only did defence work. And so for the first 5 years or so of my career, that's all I did. And so by the time I came around to possibly considering doing some prosecution work, my defence practice was way ahead of where any prosecution practice would have been, because I would have had to start at the very bottom in the prosecuting, of doing sort of magistrates or very low-level cases. And by that stage, I was doing quite serious Crown Court trials for the defence. So I was actually offered a couple of prosecution briefs, but when I looked at the prosecution briefs I was being offered versus the defence work I was doing, really it would have been a huge step backward to start doing that low-level work again, just in order to prosecute. So it never really happened for me, and right through until taking Silk and thereafter, it's just not. It wasn't a deliberate decision. It's just that I never went that route, and I just circumstances took me to do defence work, and frankly, I'm much more comfortable. I feel that that's my niche as a lawyer is as a criminal defence lawyer and a criminal defence barrister in particular.
Yes, definitely, that makes sense. Chris, you did mention that you got pupillage at a defence set. So could you please elaborate on, for those trying to seek pupillage and aspiring criminal barristers, what are your top tips for applying? And if you could just give some guidance on the application process regarding that.
Sure. Well, as you know, there's a kind of very organised system for pupillage applications now, and there's a sort of standardised format for the applications. I think the short answer to your question is make sure you know what the sets that you're interested in actually do, because frankly, it's remarkable to me how many, I've sat on pupillage interview panels and so on over the years. It's remarkable how many of those applying for pupillage really have no idea what the set actually does, or what its members, what kinds of cases its members are involved in. So I think do your research is my number one tip. Make sure that I think by the stage you're applying for pupillage, you should really know what kind of work you want to do. And one of the things that I find I struggle with when I'm interviewing candidates, either for pupillage or for scholarships for that matter, is when the candidate says, well, I'm not really sure, I might want to do criminal law, or I might want to do family law, or I don't really know. And frankly, if you don't know whether you want to do family or criminal law when you're applying for pupillage, I wonder what sort of thinking you've actually put into your career, because they are two very different animals, very different procedural features, of course, as between criminal and family law, and indeed a whole range of other specialisms. So when I hear someone say, I want to do common law, or I want to do, some very broad, frequently last week in scholarship interviews, people say, well, I probably want to do civil law, as if that's just one thing, rather than 100 different things, from equity and land law right through to, personal injury and everything else, judicial review and so on. So I think focus is crucial, because getting a pupillage is really difficult. It was really difficult when I did it, but it's infinitely more difficult now. So focus, research, think carefully about which sets you're applying for, Do mini pupillages if you can, but if not, get to court, watch cases, find out, you know, if you're applying regionally, you know, in some ways it's easier because there's a smaller number of sets and a smaller number of courts. So go to the local courts where you want to practice and live, see who the sort of the sets are that are obviously the ones that are the most prominent in the courts that you want to practice in, whether that's in the criminal jurisdiction or one of the other jurisdictions. Research, focus, and ultimately pursue applications with sets that actually fit with where you want to be, not just because you want pupillage regardless, because the sets will smell that. And when we're doing interviews, we know the candidates that are really passionate about the city we're in, the work that we do, and indeed the individual set itself, and show that you have done that research. And I'm not talking about, you know, listing 57 cases that members of chambers did in a sort of, you know, almost a kind of like a sort of creepy way almost. But you know, if a set's been in the news doing a high profile case, then absolutely mention it. It shows that you really are taking some care in your application. I would say I'm going to give one absolutely golden tip that you would be amazed how often people don't do this. Make sure that your application doesn't have any spelling mistakes in it or typos. It drives me absolutely round the bend that applications from students with a wealth of qualifications, phenomenal A-level results and great degrees and so on, can't get through an application without 6 or 7 grammatical or spelling errors. I know this sounds like a small point, but trust me, it's so irritating to an interviewer to have to read something that looks like it's been typed on a phone as a text message, and it's not the way to do it.
Thanks, Chris. So yeah, last week, the Law Society members were fortunate enough to hear from the Lord Chancellor and Secretary of State for Justice, Robert Buckland QC. And we kind of posed the question to him about the backlog in the Crown Courts, which have kind of hit a record all-time high. I think 56,000 cases was the latest figure I could find. And, you know, some cases are even being timetabled for 2023. So, I mean, he's kind of set out some proposals for a recovery plan, including the use of Nightingale courts and more remote hearings. So just from your experience, how do you think the COVID-19 pandemic has affected hearings and trials?
Well, the effect has been massive, and I'm right in the middle today of writing an afterword for the book because the paperback edition comes out in the summer, and I've been looking at this issue of justice under COVID, and you know, the fact of it is that the impact has been quite catastrophic in every single way and by every single measure. So victims of crime have to wait longer and longer to give evidence. I act for a number of victims of serious crime, including young women who are victims of rape or serious offensive domestic violence, advising them on their rights and the process. And many of them are looking at trials well into next year, and sometimes 2 years after the attack, before the case gets to trial. And almost as bad, if not worse than that, is because of that delay, the attacker is being released from prison on bail because the court won't allow them to be remanded in custody for such a long period of time. So the impact on victims is extraordinary. The impact on defendants who are on remand or waiting, potentially not able to work or suspended from employment in some way because of huge delays to the case is extraordinary. The impact, of course, on our society of a criminal justice system that is barely functioning. I mean, it's in a state of what I would call cardiac arrest at the moment. In reality, we've, you know, one of the statistics I came across in my research today as I was writing was that we've seen a drop in the prison population, in fact, of 6,000 over the last 12 months. Which on the face of it, you could say, well, that seems like a positive because prisons are so overcrowded and prison numbers are so high. But the only reason is because the police have not been charging as many people and prosecutors have not been prosecuting as many people. And you've rightly pointed out there's this huge backlog. So the system is a state of utter crisis at every level, from policing through to probation services. Of course, everyone involved as a practitioner, as a lawyer in the criminal justice system has seen an enormous impact on their workload and on their work life. But in terms of a journey through all of this, The only way in which we can deal with the crisis in the criminal justice system is the same way in which the government has sought to deal with the crises across our society and our economy, and that's to flood the system with cash. You know, the government has spent hundreds and hundreds of billions of pounds to prop up the hospitality sector, huge amounts on the furlough scheme, industrial support, benefit, loans to businesses on very favourable terms. But what have we seen in the criminal justice system? Next to nothing. The criminal justice system is being treated like a third-class part of our infrastructure and of our civic society. And the only way in which you can recover from this is to see it as an emergency in the same way as that the health service and education and various other parts of society and the economy were seen as emergencies, and just throw money at it. That means opening up new court centres, and it's no good just having Nightingale courts or courts sitting at the weekend or at night time, because that's not realistic. It's not realistic for the way that jurors are living their lives, the way that lawyers live their lives, people with children. You can't have trials running at midnight. You can't have trials running Saturday and Sunday with juries, because it will mean that all of those involved are placed under intolerable personal pressure. So you just have to open more courts. They were already massive numbers of court closures over the last decade. We already have an inadequate court infrastructure and inadequate a number of people working within the system. And the only way in which you reverse that trend is to spend a huge amount of money on it. And sadly, Robert Buckland, I doubt whether he told you he was going to do that. And I know for a fact that it's the one part of our civic society that is, as I say, getting shortchanged with all of this money that's being thrown around on so many other things.
I suppose there's a lot of talk as well about what will be the new norm post-pandemic. I mean, what's your experience of remote hearings? Do you think they're here to stay?
Yeah, I think there's two very, very different issues at stake here. I'm a big fan of remote hearings. I mean, I've done many remote hearings over the last 12 months, many more than I'd ever done before. I've done a handful in total before that, usually because I was in one part of the country and had to deal with a hearing in another part of the country. Whilst in the middle of one case having to deal with another one. But in terms of the ability, I mean, I've been in the Court of Appeal sitting in the next room here at home, fully robed in all my silk gown and everything else, in the Court of Appeal doing hearings. And I have to say, I have got to the point now where I don't think there's any measurable difference in the quality of justice between justice dealt when I'm not talking about jury trials, but anything except jury trials. I don't think that there's a discernible difference. And so what that means is it is another way in which we can start to get things moving again if we make it the default position that non-jury hearings are remote hearings, and only in exceptional circumstances is it necessary for the parties to travel to a court to deal with a hearing. And one of the reasons for that is because it's so much more efficient. When you can deal with everything in time slots in the way that we do on Zoom and the way that the court system does through the use of the Skype technology that's used for court hearings in most cases, you could theoretically, I mean, I was talking about my younger days of doing a dozen briefs in a day. Now, actually, that was really traumatic and difficult because it was really difficult to coordinate the timing of those hearings. But if everything is strictly timetabled and everybody knows what they're doing and everybody has the right technology, I mean, I had to have a new fibre line installed at my house because I couldn't operate on the previous technology that was here. So provided everybody's got the infrastructure, and that's a big part of the country's recovery, of course, has got to be infrastructure, including the internet and including fibre everywhere. But if everyone has the technology and it's robust and it doesn't break down all the time, as it previously often did, then I actually think it could be a big part in getting us through this and getting some of that backlog down. So technology is a good thing. I'm not a big believer that judges need to look someone in the eye or that all of that stuff. I think we can all cope with communicating in the way that we are now much more. The one area where I have severe reservations would be around having remote jury trials. I just don't know how you could ensure that juries were secure and not communicating with third parties or being influenced in any way. And we haven't gone down that route. We haven't gone down the route of reducing jury numbers, which I also think is important because it's a slippery slope. Once you say it could be 8, it could be 7, it can be 5, it can be 3, it can be none. So I don't want to go down the route of reducing jury numbers or reducing the use of in-person jury trials. But for almost everything else in the justice system, remote hearings are much more efficient.
Thank you, Chris. I think it has been great to get your perspective on the pandemic's impact on the criminal bar. Would you like to elaborate on the issues regarding legal aid cuts? And since it is a publicly funded bar, what do you think might be the downs of the life of being a criminal barrister, and specifically in the junior end nowadays?
Yeah, I mean, I think the junior bar, if you treat the junior bar as part of public service in the public sector, which I appreciate is technically not the case because junior barristers are mostly self-employed, although by no means all of them. Many work in employed practice, for example, at the CPS and so on. But if you treat the junior bar in that way, as part and parcel of the fabric of public service, then the junior bar has suffered almost more than any other group of young junior workers within the public sector. You know, incomes of junior barristers in real terms have fallen by up to 50% in the last 11 years. And so when you think about that, the impact on that has been really extraordinary. We've seen a significant reduction in the number of criminal pupillages. We've seen a significant reduction in the average income of junior criminal practitioners and junior tenants at the bar. We've also seen a diversification away from pure criminal practice, pure publicly funded criminal practice in particular, and towards mixed practices involving junior criminal barristers increasingly doing professional misconduct work, whether in policing or in the professions, increasingly doing some civil work, particularly in areas that may be linked to crime, such as civil actions against the police, judicial review, administrative work, often quasi-criminal in nature. So I think one of the things I would say is that the days when I did my pupillage, and I described doing the 20 trials in a month and so on, those days are, I think, over. And I think anyone going to the criminal bar, there are some that still just exist on a diet of exclusively publicly funded criminal work. But I think be prepared to have more strings to your bow, and be prepared to go and do a case in a tribunal that may not be wholly familiar to you. So the need to research around that and to be prepared to get in at the deep end and do cases in an unfamiliar environment is something that's much more part of the landscape now. And also be prepared to be flexible about your career path, because anyone going into it on the basis, I am committed to doing nothing but publicly funded crime, may find that there just isn't enough work sufficiently well paid to sustain a career in the short term in that way. And also, think carefully about any opportunity to do privately funded work is a really important opportunity, because by diversifying income streams, as many chambers are, away from pure publicly funded models to a mixed private and publicly funded model, those are the sets that are actually thriving, and many are thriving. But those sets which are still wedded to legal aid alone and public prosecution alone are the ones that, sadly, many of them will go under in the current climate.
Perhaps taking it back a step, Chris, before students have even got to the junior end of the bar, as an experienced practitioner in QC, have you got any advice as to how students can improve their advocacy skills? Because I know in many ways it's not the same public speaking experience over Zoom. I mean, it's kind of a relief to me not to be able to see 64 other faces all staring at me in a room. But do you have any advice for advocacy?
My advice is not to have that mentality. I mean, absolutely, the advocacy is about communication with other people, and it's about having confidence in how you communicate with other people. And the only way in which you improve and enhance your skills in that regard, or increase your confidence, because of course many who end up being very good barristers, when they're students and haven't been exposed on a regular basis to advocacy or public speaking to large numbers of people, many lack confidence. And I would say that for those of you who are toying with the idea or even seriously considering the idea of a career as an advocate at the bar or otherwise, and if you feel, well, you maybe have a little bit of a lack of self-confidence when it comes to public speaking, I don't think there's anything unusual about that. I mean, I think I would say the majority, certainly a large number of those who end up being really successful advocates started off with the same sorts of concerns and the same issues of confidence. And the way in which you get around it is a really simple one. You just have to do it. You have to take every opportunity to speak to audiences or to others, whether it be online or whether it be in person when things start to get back to normal. You just have to do it. And even, it doesn't have to be in the context of the law, it can be in any context. So if you're interested in politics, then speak to political groups and organizations. If you're interested in drama, you know, get on stage, do stuff on stage, because anything that builds self-confidence and builds competence when it comes to communication and public speaking, those are the ingredients of successful practice as an advocate in particular. And also they are the things that you will need to demonstrate to chambers if you're applying for a pupillage. And also if you're applying for a, you know, for a scholarship at the Inn, and I'm bang the drum, please do apply. If you haven't already, look into the Inn scholarships. I'm an interviewer, chair of interview panels for Gray's Inn, so I'm, you know, going to bang the drum for Gray's Inn, obviously. Some of you may have joined in as student members already. If not, join Gray's Inn is my message. But absolutely apply for scholarships. But you will have to prove to the interview panel that you've done things to demonstrate your suitability for practice as a barrister, and public speaking, advocacy, whether it be in free representation units or such like, anything that allows you to explore your ability to communicate to an audience of 1 or 100 or 1,000 is good when it comes to demonstrating you're pursuing the right career. So practice it, do it. Don't be afraid to do it. Don't be afraid of any audience. You can stand up in front of any audience and speak about anything. But one other thing I would say, just as a basic kind of premise of being a good advocate, is it's not actually about how confident you are, although that's really important. It all comes down to preparing carefully the things you want to say in advance, because people get nervous when they don't really know what they're saying, not when they do. So be well prepared and just get out there and do it. And the more you do it, the less you will worry about doing it, and the better you'll get at doing it.
That was great, Chris. I think the emphasis you put on preparation is quite important as well for aspiring barristers and solicitors. I was wondering, so as we can see on the screen behind you, your book, Justice on Trial, could you tell us more about how you started writing and researching? And then you also mentioned your time with BBC, so if you could please elaborate on that.
Yeah, so it, like lots of things, I suppose, you know, I talked about the sort of pure chance that my parents would have moved within a mile or so of a brilliant sixth form college, and so that I didn't end up, you know, either leaving school and education altogether. But when it comes to the book, I mean, basically, once I took Silk, for the first time, I really had the chance to reflect. Not, you know, because one of the things about junior practice is that you're so busy, if you're lucky enough to be busy, but you're so busy with what's in front of you. You're so busy with the case you're doing, the next case, the 12 documents that need drafting, the you know, the conferences that you need to do. It's a high volume activity being a busy criminal junior, that you rarely think, or at least I rarely thought about why I was doing it. You know, it's one thing to go to work and do the job you do, but I suppose one way I would look at it is that for many years, it was equivalent to going to work and digging a hole every day and then filling it back in again, but never questioning why I was doing that. And you know, it just seemed like it was hard work, as digging a hole and filling it back in again would be. But ultimately, was it work that was to any great purpose? So after I took Silk, I began to reflect on that. And, you know, one of the conclusions that I came to was actually, my job was pretty much like digging a hole and filling it back in again. And that's what the criminal justice system is largely like, because it doesn't actually achieve the aim for which it's invented and the purpose for which the public expect it to fulfill, which is to reduce crime and to make society a better and safer place. You would hope that's what the criminal justice system is for, and most people in the abstract would say, yes, of course it is. But the problem is, when you see year after year prison populations increasing, violent crime and sexual violence increasing, domestic violence increasing, and these kind of areas of real public concern getting worse, you have to say to yourself, well, hold on a minute, is the system fit for purpose? And so what I did was I started to analyze, you know, what's wrong with it? What is wrong with the system that where the outputs at the end of it are the exact opposite of why we have it. And the answers that I came to, and you know, were fairly simple, but I hope quite intuitive. They were around, and the book has a number of kind of chapters, but some of them really got very simple titles, like why we should close all prisons, and why we should legalize all drugs, and why children are never criminals. And I started to kind of realize that there were these kind of broad areas where we were going dramatically wrong. By criminalizing children, we were creating this kind of a generation and generation after generation of adult criminals. By criminalizing drugs, we're creating more and more crime and more violent crime. And by locking people up in prison for ever longer periods of time, which Robert Buckland is a big supporter of, as you may have seen in the last few days with the announcement of even greater sentences for a range of crimes, you know, we're just perpetuating criminality. And so I've started to write a couple of articles for The Spectator and The Guardian, The Independent about this. And I wrote an article arguing for the legalisation of drugs in The Spectator, which you can still find if you're interested online. And I got an email from Bloomsbury, who's a major publisher of Harry Potter, amongst other things, which is probably a more interesting book than mine, but it certainly sells better. But I got an email from them and they said, look, will you let us come and speak to you about writing a book? So I said, yeah. They came to my chambers, and my editor, now editor, young editor from Bloomsbury, and you know, within a couple of weeks, we'd done a deal. And within a couple of months, I was on the research trail. I recruited researchers. I was also traveling to the States and around Europe. And then within a year of that, the book was out. So, you know, it all happened quite quickly. But likewise with the TV series, I made a series for BBC One, which went out last year, called Crime, Are We Tough Enough?, which is on iPlayer if anyone wants to have a watch of that. And that came about in a similar way, just random meetings with people. And, you know, I started to express some of my opinions about these issues, very similar issues to the ones that we covered that I cover in the book. And we filmed that series throughout 2019, and it went out about a year ago. So, you know, and there are other TV projects on the go. And to be honest with you, I kind of found it really fascinating to be able, because when I'm doing my day job, I've stuck with the criminal procedure rules. I'm stuck with, you know, the legislation. I'm stuck with sentencing guidelines. I'm stuck with judges telling me what I can and can't say and when I can and can't speak. But making a television show or writing a book, I can do and say whatever I like, just as I can on an event like this. So it's been really quite liberating and fascinating to me to be able to let the, you know, shackles come off and say exactly what I really think about all of these things, with the benefit of all of the experiences that I've had.
Hi, Chris. Thank you for speaking to us today. I just had a couple of questions. I found it really interesting when you were talking about the backlog. And obviously it's a major issue within the legal system, regardless of COVID, the length of time the criminal procedure takes. And I was just wondering if, obviously you were saying it's important to, you know, flood the system with money and whatnot, but I was wondering if there were any sort of, you had any long-term solutions, because victims and defendants do have to wait such a long time, and it's very detrimental, I think. I think they need some support in this sense. And also my second question was more to do with the decriminalisation of drugs, and whether you think that the UK could go like in a similar way that the Netherlands have gone and decriminalise marijuana within the next 10 years, maybe?
Yeah, well, good questions. I have to say, I'm actually not in favour of decriminalising drugs. I'm in favour of legalising drugs, licensing drugs, and regulating drugs, which is not the model that they have in Holland. It's not the model that they have for cannabis or marijuana in the US, which is an entirely commercial model, largely unregulated product. They have decriminalised in many states, but the problem with decriminalisation, which is also the model that they have in Portugal, as you probably know, is that it leaves the drug supply chain in the hands of criminals. And that, in some ways, is the worst part of the current system, is that organised crime is responsible for supplying everyone's drugs. And when organised crime is supplying drugs, they don't do it in a responsible way. I'm not saying that all suppliers of legalised and licensed products are responsible, alcohol, for example, and tobacco. But what we've done with tobacco and what we've done with alcohol, but certainly particularly with tobacco, is that the regulation of the product and restrictions on advertising and the use of taxation has been used to control the supply chain and to in other words, to ensure that what gets to the end consumer is quote unquote safe, unlike in a decriminalized model or a prohibited model. So going back to your question, Joe, so legalize, license, regulate. No country in the world actually adopts a system that I advocate of complete legalization and regulation. I talk in the book about Switzerland, where they have a really pragmatic and sensible approach to heroin supply, which is largely through licensed clinics and a medical model of heroin supply, so that users effectively get free heroin twice a day in safe conditions and so on. That's much closer to the model that I prefer than simply, if you decriminalize cannabis, the problem is that the supply chain wouldn't change. And not only is that a bad thing because of organized crime, it's a bad thing because the cannabis that's currently in circulation, much of it is so strong in terms of THC content, in terms of psychotropic qualities, that inherently it is quite dangerous when it comes to long-term mental health, as opposed to a licensed supply chain, which wouldn't necessarily constantly hike up the strength of the drug and constantly try and make people more dependent on it, regardless of its impact on health. And the reason that that happens, of course, is because criminals supply it. So licensed and regulated. Yes, the obvious longer term solution arising out of my book is that many fewer people should be in the criminal justice system, full stop. We criminalise people at a very high rate in Britain compared to other Western European nations, and we imprison them at the highest rate of any Western European nation. It's still nowhere near the US, where they have almost 2.5 million people in prison. We're sitting at just below 80,000 as of today, 78,000 or thereabouts. But one answer is to not always reach to criminal justice as the answer for everything. You know, when you have particularly young people, and as I say in the book, I advocate that we should take those under 18 out of the criminal justice system altogether and place them into a sort of different track in terms of education and rehabilitation and support, rather than sending them to youth courts just to train them to become criminals, which is basically what happens with the youth justice system. So if you were to divert large numbers of young people from the criminal justice system altogether, and if you were to focus really carefully on which cases are prosecuted and look at whether there are alternatives to divert people from the criminal justice process without taking up court time and resource, I think some sort of diversion strategy and a really careful, hard look at what as a society is our priority. Is it to criminalise as many people as possible, which is, you know, inevitably going to lead to a very busy criminal justice system and a massive overcrowding prisons and delays in the court system? Or is it to reduce crime and to reduce the amount of violence in our society, in which case mental health services need to be improved, because those with serious mental health problems occupy an enormous chunk of the criminal justice system's time. Likewise, those with addictions. You know, if you follow my route in terms of legalization and licensing of drugs, those with addictions are given proper medical support. Then much of the kind of population of our criminal justice system and regulars going through the system, again, they wouldn't be in the system anymore. So my book's kind of a joined up thesis as to how you reduce the overall use of criminal justice and imprisonment, and you look to address the underlying causes of criminality and criminal behaviour. So I think you have to link it all together. But there's some easy wins, and the most obvious one is legalising drugs, because if you do that, the prison population will halve in a generation, and probably more quickly than that. And that will mean that these delays and the backlogs that they create are less significant.
Thanks, Chris. Abdullah has the next question.
Yep, Chris, cheers for your talk, and I quite like your stance on legalizing drugs. But it's sort of a question and a comment. I think it's quite a sensible approach, considering how the war on drugs has been going for the last couple of decades. But in terms of perhaps a comment and a question, do you reckon that really does prevent or diminish the amount of crime involved around drugs? Because you spoke about tobacco, but at the same time, the UK sees millions of cigarettes smuggled into the UK because they're sold for cheaper prices. And the second question, which is also drug related, if possible. So since the new sentencing guidelines in relation to drugs offenses are coming in a few weeks, the question is, since they lessen the sentences for street dealers, how does that impact people who have been convicted on based on the previous guidelines into longer sentences? Don't you think there's a bit of an injustice that occurs there simply because the offense took place a year earlier than it would if the new guidelines would be implemented?
Well, I don't think it's an injustice because the law is the law at the time that you are sentenced. Although interestingly, sentencing guidelines often come into force and apply to all cases sentenced rather than all offences committed after that date. So you could argue that somebody who has committed the offence now and is then sentenced on the new guidelines, well, they've had a benefit because because when they committed the crime, the guidelines said one thing, and when they were sentenced, it said something more advantageous to them. But of course, on the flip side, you point to others who have the opposite effect, who may have just been sentenced to 2 or 3 years longer than they would have got if the new guideline was in. I mean, I'm not a big fan of sentencing guidelines full stop. I think they are deeply damaging to our criminal justice system, and in particular in respect of drugs, have been responsible for the vast increases in our prison population over the last 20 years. You know, I have clients who have either been convicted and sentenced to terms of 25 or 30 years, or I've advised clients who are looking to appeal sentences of 25, 30 years, or even longer, in one case 40 years for the supply of heroin. So all of those drug kind of sentencing guidelines have been really quite catastrophic when it comes to the impact on our society. So I would say that it's a positive move that that we're looking to reduce sentences for street dealers because most street dealers are actually just drug users who happen to also or have no choice but to deal in order to pay for very expensive drugs. But to go back to your question about tobacco, that's a really interesting and important point that you make. Why is there a market, and I have to say it's a relatively small market in comparison to the total tobacco market, but why is there a market for cigarettes that are imported illegally without duty being paid? And the answer is because of the price of cigarettes in Britain. So because the duty and the tax on tobacco is so high in Britain, and I believe, although I've not smoked for many years, but I believe that a packet of cigarettes is now around £10 or more. Okay, so obviously if you could import cigarettes from Turkey or Spain or wherever where duty is much lower, or even duty-free cigarettes, and sell them for £3, £4 or £5 a packet and still make a good profit, there's going to be a market. But that's because it's £10 a pack of cigarettes. With drugs, I used heroin in Switzerland as an example. The last thing you do is sell the heroin for a high commercial price, because if you do that, you will create you will still have an underworld or organised crime market to undercut the legal and licensed market. How big it would be is another question. So what you have to do, by legalising, licensing and regulating, what the government has to do with drugs is control the price of the drugs. Now, governments can do that very easily because the government can just buy the drugs and supply them in a monopoly system. So cocaine, for example, is about £1,000 a kilo at source in Central and South America, pure cocaine. By the time it's been chopped up and chain on the streets of Britain, it's about £100,000 a kilo. Now, the reason for that is because all the profit made on the way by all the middlemen who are exporting, transporting, selling, reselling, and so on. But if the government just says, okay, we're going to buy 1 million tons a year of cocaine, pure cocaine, that's only going to cost the government a tiny fraction of what it costs drug dealers to buy those drugs. And the government can supply those drugs through licensed dispensaries or networks for a cost which would make it completely uneconomic for an illegal supply chain to develop. So provided you control the whole market, and you don't have a private market and competition and profit, you can actually control the supply chain. And in Switzerland, they've done that with heroin very effectively, because when you can go and get free heroin from a clinic in clean conditions, sterile conditions, why would you go and buy them on the streets for 5 times, or 5 times as much, or pay for them at all? And yes, there is still a small illegal market for heroin in Switzerland. It's not gone completely, but it's very small, much as our tobacco market is very small here. So you're always going to have someone on the margins who's able to kind of make a profit from buying and selling stuff. But overall, the health benefits of the legalised and licensed system I'm describing are so big that it is absolutely overall the right thing to do.
Previously during your talk, you mentioned the effect of bails, basically people on bail and such, and also their victims as a result of the pandemic. Do you foresee the sort of like the consequences of COVID being a permanent factor when courts are considering bail applications and requirements and such?
For the time being, yes. I mean, I don't know about permanent, because who knows what permanent looks like in this day and age. But for the time being, COVID will continue to be the dominant feature in applications for bail and throughout the criminal justice system in terms of the operation of the courts. So I think it's here for the short term. In the long term, my fear actually is that we just revert to doing things exactly the way we did before COVID. And that, for me, would be a real mistake. And one of the things I'm writing about, and was writing about just today, is why I'm very frustrated that this quite extraordinary period of history appears to have taught our policymakers nothing. And we are still seeing sentences increase, reduction in the amount of remission and license time. We're still seeing, whole life tariffs have been announced for teenagers. Now, the idea that anyone under the age of 21 or, a teenager should be sentenced to life without parole, using the American terminology, is just abominable to me. That you would say that anyone is beyond any redemption. Potentially, they might live for another 90 years and never be released. It just doesn't make sense to me. So sadly, I think we're not learning the lessons. But as far as bail is concerned, in particular, COVID has been a big dominant factor. And I've had contact with a client today, a young woman who is waiting for her attacker to be tried in a rape case, and he was released because of COVID delays. As it happened, he breached his bail and got locked up again. But she lived in fear of him coming to attack her, because he was only released because of COVID. So that's most people only look at it from the defendant's point of view, but victims are just as much impacted by these things as anyone else.
Just a last question. It's not an audience question, but if you were not a barrister, what profession would you choose instead? Just a fun question.
Well, that is a fun question. And those of you who have done their research and perhaps have been to my YouTube channel, which I'd recommend, by the way, because it has a dozen videos that I made for law students in particular last year during lockdown 1, may have come across the short film that I made for the BBC a couple of years ago called Raising the Bar, in which I talk about this exact issue. And the answer is actually really quite a mundane one, which is that the reason I am a barrister now, I'm sure there may be other reasons, but certainly the source of my kind of inspiration, I talked about going to the courts in Liverpool and watching trials. Why did I do that? It wasn't just out of the blue. And the answer is because I did a computer-based careers test at the age of 16, probably just maybe 16, 17. And I answered all the questions about what I liked and didn't like. I'm sure many of you have done these in the past, these careers aptitude tests or whatever they're called. And the computer in those days gave you a printout on paper, and it said that Chris Daw was suited to be one of two things, a barrister or an actor. And so actor, I think, is probably the other route I would have taken. I just wasn't good enough. That's the problem. But the truth is, I do have another career now as a writer and as a broadcaster. So I kind of have two jobs, and I'm quite happy to combine the two. And it's they actually work quite well together. So yeah, but would I have loved to have been a good enough actor to be an actor? Of course, because it would have been great fun. I would have enjoyed it. But actually, I get to make up my own lines in my current job. So maybe that's the best of all worlds.